Hello, everybody. Welcome to our first panel. I'm going to say a few quick words of introduction for our three panelists, and then I'll let them carry away the show. My name is Aaron Schneider, and we have three panelists today. Dora Shiro is the Commissioner of the New York City Department of Correction. Commissioner Shiro served previously as the Special Advisor to DHS Secretary Napolitano, was the first Director of the Office of Detention Policy and Planning with Immigration and Customs Enforcement. Bob Little is Grassroots Leadership's Senior Organizer. He's based in Austin, Texas, led the group's campaign to end immigration family detention, an effort that successfully contributed to the end of family detention at the Teton Plateau Center in Taylor, Texas. And Alger Kendall, most recently served as County Judge of Karnes County, Texas from 2003 to 2010. He has also served as County Attorney in Karnes County and as District Attorney for the 81st Judicial District in Karnes County. I'm going to turn the floor over to them in the order that they appear in the program. They'll each have about 15 minutes to speak, and we'll start with Dora.
Okay. We've been in agreement, we're all going to stand up, so better honor that agreement, Brian. So good afternoon. I am tickled to be here. I am new to the immigration reform conversation, but I am not new to reform. I am a jailer, and I have run 2 state systems and now 2 city systems. And so it was with that corrections hat that I joined the secretary who had been just before my governor when I ran the Arizona Department of Correction and went with her to Washington, D.C. The secretary is a remarkable person. I would not have gone from Missouri to Arizona to work for her, and I would not have gone from Arizona to D.C. if that was not the case. She was as concerned as any of you about the state of immigration detention. And she knew that it was something that could mire the administration. And like her approach to all things, which is very no nonsense, she wanted to get to the bottom of it. And that's where I come in. My job was to figure out what was what, and to identify not only what worked, what didn't work, what could be, but also what could be improved, what needed to be improved. And my charge was to write a comprehensive and candid report summarizing those observations and those findings and putting forth those recommendations as a platform for conversation, a platform that could and should lead to reform of the immigration system. And so my query was really about how do we make civil detention civil? And that was indeed the subtitle of the report that I provided to the secretary. I approached the work clearly with a strong frame of reference, both correction law as well as correction policy and practice. But that was a benefit because I understood why in the world of corrections we do the things that we do. And I saw many of those things being repeated in the civil immigration detention arena, but without the understanding and without the results that one are expected to achieve in the world of jails and prisons. It was striking to me when I looked to the available law to see what there was as mandate, because unlike the field of corrections, where there is abundant case law in the last 40 to 50 years, there is virtually no case law on the civil side. And that is still a challenge for the rest of us. But one thing is quite clear in the very limited case law that exists, and that is whereas correctional systems are created in statute for the purpose of holding persons who are charged with crimes pending the resolution of those criminal matters, and then to further detain them, incarcerate them for the purpose of punishment when the court so determines. That is expressly not the case in the area of immigration detention. That ICE is clearly charged only to hold people, certain people, for the express purpose of, until the determination of either removal or relief is accomplished. And in some instances, the decision to detain is mandatory detention. Those reform is such a funny word, isn't it? The way it can get used both ways. From the reforms by Congress in the mid to late 1990s. So it's really striking how little there is, and so then the conversation about standards. Well, I think we had so much sense of urgency about them, and particularly standards that might be incorporated as in statute as regulations, because with regulations comes the opportunity for enforcement, as does the opportunity for case law to afford. As I marched around the country, I went to 25 facilities, some of them more than once, some of them causing me great more concern than others, but all of them raising levels of concern. And with talking with extraordinary individuals and organizations around the country, as well as legislators, and reading any number of reports by organizations that were publicly and privately funded, reading reports by government itself, one of the things that was so striking is, from all these different points of view, the commonalities in the findings. And indeed in my report as well, although there is unique and probably more in-depth conversation about a number of areas, because in fact the Secretary afforded me unimpeded access to anything, to everything, that I could request, that I could generate any number of reports of my own volition, as well as to go to any facility at any time, unlike the press has experienced. So these common conclusions, I think, is a particularly striking thing. Because I had this in-depth knowledge and because I am a jailer at heart, I also looked at not just what they were doing and the why they were doing it, but the how they were getting it done. And the template for reform is more than setting aspirational goals, but also making the assessment about what would be required to actually realize those aspirations. The report, for those of you who have seen it, organized all the information into seven interactive categories, buckets I used to call them, but different facets of disciplines. And so I looked at the core assumptions about population management. Who was ICE going to take into its custody, and where along the continuum of control, from the least restricted, which would be released to the community with personal recognizance, through intermediate strategies, through hardcore incarceration. The next was detention strategies, something that's of great concern to everyone in this group as well. For those individuals that are either being supervised in the community or being detained in these immigration facilities, detention facilities, what were the core assumptions that drove the conditions of that detention? There was also a great concern as a subset about the alternatives because of the way in which they were being used. So although population management includes alternatives to detention, for the purposes of the report, it required so much attention that it became its own piece of the conversation. There was also considerable concern about programs management, and the biggest and the most fundamental of those programs is healthcare. And so considerable attention was spent in that discipline. In the bigger arena of programs were those several things that ICE, emulating the corrections world, had identified as being mandatory. Now there's also federal law in several instances that further drive it. So religious services, and of course RLUIPA, that goes with that,
and then access through the courts, in this case again through law libraries primarily, and to a far lesser extent, and not included in the standards that were promulgated by ICE, the legal orientation program. Visitation is fundamental in the corrections arena, and so that was identified by ICE and by me and many others as well as an area of great concern. There was also then all the modifications that really needed to be done and frequently that were not occurring for what I then identified as a special modulation, which are the special populations. It's not a one-size-fits-all, although that's how it frequently appears for individuals who are either detained or for those who are coming in and concerned about it, as well as those who are actually accomplishing it. And so modification by gender for men versus women, modification for special categories of detainees, particularly asylum seekers, modification for families with minor children who are being held as family units, as some of the examples. Of all of the groups, the one that I thought was perhaps the most important because it really drove the others is what I called accountability. And that really spoke to the transparency with which government approached the reforms, the way in which it collected data, and the way in which it was willing or not willing to disseminate that information. At the end of the day, there were any number of findings in each of those 7 categories and any number of recommendations that went along with it, indeed leaving ICE with a cookbook, if you will, about how to actually accomplish each of these goals. But there were four big groups of observations. And the first is that ICE, although we call it a system of detention, a system of civil detention, that system is really an aspirational term, because what they have is a number of strategies, at least at the point of the report, and I think that's still largely the case. But they really don't have an integrated system, and you could see that in all the news accounts and still the reports that are coming out. The difficulties in finding an individual or any group of individuals who are being detained by ICE, or to know with certainty their location, or for ICE to actually have policies and procedures so that there was a consistency in the operation and not the individuality that we still see to this day. Likewise, a number of the concerns and the findings, again, focused in the area of healthcare. And again, although they talk about a healthcare system, that too is aspirational, that there are a number of strategies so as to manage healthcare, but clearly still some pretty appreciable shortfalls in accomplishing those goals. There, again, about to the accountability that there needed to be all sorts of systems that collected information, and that information needed to be made available to the public on a real-time basis. I'm sorry? Excuse me one second. And back to the point about the standards, that in consultation with stakeholders, that ICE really needed to promulgate standards that would be unique to what is, by the way, the largest, here I go again using that word, system, but the largest organization of detention in the country. It is bigger than the Federal Bureau of Prisons. It is bigger than the state of Texas Department of Correction. It is bigger than the California Department of Correction. It's bigger than Illinois or New York. In the course of a year, as our keynoter had kicked off the conversation, in the course of a year, it's some 400,000 individuals that come through this system, if you will, of civil detention. So on a given day, not necessarily the biggest, some 30,000 give or take, so more a medium-sized system. like Missouri, which I led, as well as Arizona that I led. But in the course of a year, touching many more lives than any of the correctional systems in the country. And so just for size alone, just for the impact alone, and of course because of the unique legal charge that these are persons expressly not held for the purpose of punishment, expressly the prohibition of punishment, really drove the necessity to create standards anew. I've been reflecting quite a bit and still stay involved through happy conversations like the one we're having today with the immigration issues. And many of the folks who I've come to meet had the honor of meeting in the time during ICE and since then. And as I look back, and if I was going to summarize at a very high level the recommendations, I would characterize the things that are really needed to accomplish the reform. So many of you today are going to talk about what those reforms ought to look like. I'm an implementer, I'm a reformer, I run systems, so I'm thinking about, okay, how am I going to do it? Because getting it done is really what it's all about. I'm concerned about capacity, I'm concerned about competency, and I'm concerned about commitment. And so capacity, just as I ran through real fast those 7 categories, does ICE as an organization have the capacity to effectuate the reforms that have been committed to by ICE? There's also the competency, and that's having all the systems in place, but also having the individuals in place, individuals with expertise to actually accomplish these goals. One of the major shortfalls that I observed from day one through my last is that ICE excels at enforcement, and indeed, since the time that I left, they've actually changed the name of the unit from detention and removal operations to enforcement and removal operations. And so what we need are individuals who really understand the case law, understand how to deliver a system, how to ensure that that system is in fact a civil system of civil detention. And then of course there's commitment. But commitment from my perspective, and it's a little bit of a perspective from Laura's conversation, is not just about government. It's the commitment on all of our parts to see this thing through, to keep one another honest throughout the process, to be a part of the solution and not just be the individuals who are pointing out the problems. So I will leave it there, and I look forward to hearing from my co-presenters. Thank you.
No, yeah.
Bob Libble. Thank you. So can everybody hear me all right? I apologize, I've got a little bit of a cold, so I'm sorry if I'm a little bit gravelly. So my name is Bob Libble, and I am actually far from a jailer or a jailer at heart. I'd actually never heard that before. But interestingly, I think I share many of the same conclusions, not all of them, as Commissioner Shiro does, regarding the ICE detention system. I work with Grassroots Leadership, which is a 30-year-old social justice organization based in the South that works to eliminate the profit motive in the incarceration and immigration systems and to reduce reliance on detention and criminalization in those systems as well. We've operated our office in Texas since 2003, and we are part of a coalition called the Texans United for Families Coalition that began vigils and protests outside of the T-Don Hutto Detention Center in Taylor, Texas in 2006, when it had reopened as a family immigrant detention center that at the time of its opening had immigrant children, including toddlers and babies in prison garbs. It's operated by the Corrections Corporation of America. That effort, combined with litigation and an enormous amount of media, both in the States and internationally, I believe contributed to the successful end of family detention at the Hutto Detention Center in 2009. The Hutto facility was converted into a women's facility where up to 500 asylum-seeking women are detained on any given day, mostly from Central America, but also folks from East Africa and the Middle East. And we currently co-sponsor a visitation program that goes to Hutto and visits women who are detained there. I've also visited a number of other detention centers in Texas, either to visit people who are detained socially or on sort of human rights tours of these facilities. And Grassroots Leadership also does a great deal of research about the private prison industry and immigrant detention and criminal justice systems. We're a proud member of the Detention Watch Network, which I know several folks in the room are as well. And we helped gather some of the data that was used in DWN's really terrific report about the private prison industry and the detention system, which I encourage everybody to read at detentionwatchnetwork.org. And I also edit a blog called Texas Prison Business that monitors the private prison industry in Texas. Texas is home to more private prisons, jails, and immigrant detention centers than any other state. We have some of the speculative detention facilities that Lois Sullivan mentioned. We recently had a detention facility that literally was auctioned off in Littlefield, Texas, out in West Texas. They had an online auction and a bidder paid $6 million for the facility and then promptly backed out of it, leaving that community is $9 million on the hook for that facility. So that's a little bit about what we do as Grassroots Leadership. So I have a very different perspective than the other panelists. We're much more of an advocacy and organizing outfit when we do a lot of research on this issue. What we've seen in Texas, like in the rest of the country, is a dramatic increase in the number of people who've been deported in the last 10 years. And that's corresponded with a rapid increase in the detained population in Texas. We have about a third of the nation's detention beds. More than 10,000 people are detained in Texas on any given day. Immigrants in Texas, immigrants who are detained in Texas include asylum seekers who are apprehended at the border or turn themselves in at the border and seek asylum. We have, a great number of economic migrants. We have, long-time undocumented residents who are detained after being apprehended in immigration, local law enforcement collaboration programs like Secure Communities and 287G. And we also have a large number of long-time permanent legal residents, right, who are detained in Texas detention facilities, who are mandatorily detained often because of the 1996 immigration laws that say if you have committed a certain class of crime that does not have to be a violent crime, you're mandatorily detained pending the deportation. And immigrants detained in Texas include those who are apprehended in Texas, but also a large number of people who are transferred from other parts of the United States, which are often far from their loved ones, any sort of legal counsel if they have them, and most people probably know that immigrants in detention and immigrants in the immigration system are not guaranteed legal counsel, so the vast majority of people in detention are representing themselves. And they're also far from any sorts of networks of support that they may have if they've been in the country for a substantial period of time. We have some of the nation's most remote detention facilities. Georgia and Arizona may rival us in that regard. Until the conversion of the Willacy County Processing Center, which was a kind of known as Tent City in the media, it was a 3,000-bed immigrant detention facility. And 2,000 of those beds were a series of Kevlar pods. They were not like a brick and mortar structure. It was built in 45 days under the Bush administration. There were up to 4,000 immigrants who were detained in the Rio Grande Valley, which is the southern tip of Texas, on any given day. And there is very little legal representation in the Rio Grande Valley. There's some very good pro bono outfits, but they're seriously under-resourced. And there's very little other sorts of support there either. And Texas has also been home to some of the, sort of most serious cases of human rights abuses in detention. Issues of lack of medical and mental health care are pervasive in the system. The mistreatment of detained immigrants, including sexual assault, seems to be something that immigration has not been able to stem, in Texas in particular. Last summer, a supervisor at the Teton Meadow Detention Facility at Corrections Corporation of America, supervisor pled guilty to groping multiple women as he gave them a ride to the airport as a courtesy ride on their way to being released. And he was only able to do that because CCA wasn't following ICE's guidelines regarding having multiple people in a transport vehicle. Guards have also pled guilty to sexual assault at the Willisey County Processing Center, the Tent City Detention Facility, and at the Port Isabel Detention Center, both in the Rio Grande Valley of South Texas. And there have been other, sort of widespread news reports about sexual assault at the South Texas Detention Facility for several years. And according to Human Rights Watch, more than 50 allegations of sexual assault have been leveled against ICE and its contractors since the creation in 2003. And so there are some very serious and pervasive issues in the detention system, both in Texas and nationwide. And I thought it was worth mentioning, and some of Laura's graphics, I think, made me want to mention this a little more, was that although this conference is sort of specifically about the civil immigration detention system, right, and the recommendations that Dr. Schroeder made were for that system, we've also seen in Texas in particular, but also in other states, the parallel rise of immigrants being funneled into the federal criminal justice system for nothing more than crossing the border without papers or being apprehended in the country once they've been deported once. And this shift is largely due to a program called Operation Streamline, which mandates the criminal prosecution of immigrants in certain border areas. And this program has had such a profound effect that, according to the Sentencing Commission, Latinos now make up a majority of people entering the federal prison system, the criminal prison system, despite only making up 16% of the total population. And that's not because there's been some sort of major uptick in crime in Latino communities. It's not that at all. It's that the program has been profoundly impactful in pushing immigrants who would have been in the past detained in the civil immigration detention system into the criminal justice system. So you really do see this kind of merger of the immigration and criminal justice systems on this level. And while there's little evidence that Operation Streamline has contributed to the decrease in migration that it's intended, I think most migration, people who study migration say that it's the economic downturn that's contributed to the downtick in people crossing the border. The program has been a multi-billion-dollar giveaway to the private prison industry. In Texas alone, since its inception in 2005, the government has paid over $1 billion to the private prison industry to detain people in this program. We issued a report on this last summer about Operation Streamline. It's also caused what was referred to as judicial emergency in Arizona because it's so overwhelmed the federal court system. And now it's apparently contributing to a monumental demographic shift in the prison system. So I think that this program is something that's important to keep in mind as well. And Ted Robbins and NPR actually did a terrific 3-part series on Operation Streamline that's very much worth checking out. And and I'm really afraid that what we're on the verge of doing is exactly what we did with the war on drugs, right? Which was utilizing mass incarceration to deal with the social issue at a tremendous cost to human lives and taxpayer dollars. So that's a little of the context. But to turn back to the civil immigration system, I think 2 years ago, in the beginning of the new administration, many of us in the advocacy community were very hopeful that the reforms to the detention system would be dramatic. And I think that the recommendations that came out of what everyone knows as the Schreiro report, I think we were very hopeful about those. I don't know if you do that. You should Google Schreiro report. And while I think there are certainly some things to celebrate, right? The end of family detention at Hutto, and the utilization of alternatives to detention programs for families who are apprehended. a fairly good online detainee locator system, right, before it was very difficult to find your loved ones in ICE detention. I think that most advocates believe that the reforms have been a profound disappointment. The number of people in detention has continued to rise, along with the record number of deportations. The reliance on private prisons and jails has remained the norm, and utilizations of alternatives to detention for low-level migrants has not taken hold en masse. And I think that the reason for some of that failure has been ICE's dependence on private prisons and contract jail facilities, and not really having an effective way to rein in its facilities. And I really do worry that the mass incarceration industry is kind of driving the ship. And two examples of this, and I'll try to be very brief with them. I don't know if people saw earlier this week, the Houston Chronicle did a story highlighting some of the failure of oversight in the ICE detention system. And basically what they found is that internal documents to ICE show that ICE has continued to contract with facilities even when reviews show flagrant violations of detention standards, including, abusive treatment towards detainees, inappropriate relationships between guards and detainees. But basically the takeaway from the story is that ICE doesn't do anything about this. Although it did say that some of the contractor reviews of the facilities actually show much better conditions in the facilities than ICE's own reviews. Another example, I think, and it's pertinent to the conversation today, is ICE's choice in the GEO Group to operate the new Karnes County Civil Detention Facility. And this is the new facility in Judge Kendall's county that is the model for the sort of moving forward with the civil immigration detention system. There's perhaps no private prison company that has been more troubled in Texas than the GEO Group. The company has had 6 contracts ended in recent years. In Texas alone, in 2008 and 2009, a series of preventable deaths, including the death of Jose Manuel Galindo at the Reeves County Detention Center in West Texas, led immigrant prisoners there to rise up and cause more than $1 million in damage. In 2007, the GEO Group-run Polk County Juvenile Justice Center was shuttered by the Texas Youth Commission after a damning investigation into conditions at the Youth Detention Center. And that's really just the tip of the iceberg about GEO's record in Texas. And so, it was a great disappointment to many of us when GEO announced last December that it had been awarded the contract for this new 600-bed detention facility as part of an intergovernmental service agreement with Karnes County. And the facility would be a model, right, for this new civil detention system that ICE is trying to roll out around the country. ICE held no public hearings before awarding the contract and told county officials to keep quiet until the contract was a done deal, right, which really flies in the face of the transparency that the administration was trying to uphold. When ICE finally was pressured into meeting with community groups after the contract was signed, several months after the contract was signed, and we were basically told, you have no input on if this facility is built, where it's built, what it's going to look like, they turned the meeting over to GEO Group representatives to explain to community members and members of the faith community what the future of the civil detention system was going to look like. And perhaps that shouldn't be surprising, right, given the dramatic contributions and political influence of the private prison industry, as Laura laid out. But even if it's not surprising, I think that it should be troubling. And I hope that this conference sort of raises up the voices, right, of people who are troubled by this, and hopefully that collectively we can find some new ways to address these issues. And I look forward to sort of the continuation of this conversation.
Judge Kendall.
First, I want to thank you for the opportunity to be here today and be part of this conference, even though I feel that I'm the oddball here and probably will be so even more when I get to sit. But that's all right. I do want to go over a couple of things. Recently I was reading that for a recipe for good speech making, the most important ingredient is sharpening. I will try and make this sharp, keep sharpening in my speech to you. when I was making my notes for this presentation, I I kind of assumed everyone knew where I was coming from, where Karnes County was, and what we had done. And of course, Bob has brought to your attention the fact of the new facility in Karnes County. But let me just give a little bit of background, and then it will maybe explain better some of the things I say later. First, Karnes County is a county with about 15,000 population. 2,500 of that population is counted, when they do the census, is counted state prisoners, because this county has a state maximum security unit in the county. It also has a detention center by GEO Group, which we'll get into that in a little bit more. In addition, that's in addition to the proposed that Bob was talking about. The county's population, like I say, is, so we're looking at probably 13,000. Unemployment rate for the last 4 years has been between 8 and 10.5%, higher than the national average generally, and certainly higher than other areas, other counties in the area in which I'm from. Now, I had the opportunity to meet Bob. I think we shook hands, but certainly there wasn't any problem with it. He appeared with his group in the Commissioner's Court last December. And he was allowed to make his presentation. Some of the things he said, the same things we heard here today. But it was to try and convince Commissioner's Court not to go forward with the contract with the federal government and then subcontract to GEO Group. His presentation was certainly as straightforward as it was here today. But the Commissioner's Court voted 5-0 to go forward with the GEO Group. In that, another thing I heard not too long ago is that a person must be careful what they say, think about what they say, and be careful what they say, because it may be in the future they may be having to defend what they have just said. I think you see that in the presidential debates quite a bit now, but people having to defend different things that they either cough off and say or say. But I did say, and Supervisor may point out to me, that GEO has been a good partner to Karnes County for years. Said it then, and I'll say it to this group here today. In Karnes County, GEO has been a good partner. They have been involved in most community events in the county since I took office as county judge back in 2002, 2004. This year, of course, they contribute to financially to different projects. This year, in the last several years, the GEO Group has contributed at least $20,000 to local events. GEO has been, and the Whacking Hut was before, and GEO took them over, or they combined, and they've been in the county for probably minimum 15 years. The county has, even though we're only about 13,000 people, we have 4 high schools in the county, 4 high schools. GEO has contributed $4,000 a year for probably the 15 years that Whacking Hut and GEO has been there, $1,000 for each school. They have contributed over all these years I've been involved with it, $6,000 to the county for the preservation of our courthouse. The courthouse is over 117 years old now, young compared to some of the buildings here in New Orleans, but anyway, money that we need. Donations to other organizations, Karnes County City Rotary Club, annual Lonesome Dove Fest, they contribute to that. It's big for our Karnes City Rotary Club. Karnes City and Kennedy Little Leagues. The county's youth livestock show. Livestock shows are still big in that area. They contribute tremendously to that. And in the past, they were, when the county celebrated the centennial celebration back in 2004, they were the largest contributor to that organization. In addition to the financial contributions, the people in the GEO group facility participate in local events. The wardens at the GEO group have been active members of the Garden City Rotary Club, which puts on the Lonesome Dove Fest. They've been very instrumental in helping with that, in making it a success. The employees have annually participated in the Relay for Life walk, and last year the GEO group raised the largest amount of funds for this Relay for Life, and they also raised money for the Special Olympics. The GEO group in Karnes County this last year contributed $10,000 to the Special Olympics. And last year in Texas, the GEO group facilities in Texas contributed over $1 million over the last 12 years. They also participate in our local Toys for Tots. They're giving toys to underprivileged children in the county. They not only collect them, but when it comes time to distribute them, they participate in the distribution of the toys and food. I believe it was 2005, the GEO group in Karnes County was named Corporate Citizen of the Year for the Alamo Area Council of Governments area. That's the county surrounding Bear County. Now, all of the contributions that I've talked about, community involvement, is over and above any financial input that the GEO group has. The present facility, I'm not talking a new one yet, but the present facility has been there for about 20 years. Employ about 125 people. The labor and related costs annually contributes over $3.7 million. They purchase the utilities from locally, water from the Yellow Water Supply Company, which is in Karnes County, headquartered there. They pay for the sewer from Karnes City. They pay for electricity, which is furnished by the Karnes Electric Co-op. So that money, over $400,000 of the present facility, stays there. And this is in addition to any other money that may have for other local goods and services. Now, I've answered the question that I first was posed to me. Why do I think they're good partners? I want to go to another question that was posed to me, but first I want to ask a few questions. I know this group is diverse. How many people in here have served as elected official in some county, city, state? Any hands? Okay, I see no hands. And if I miss someone, please let me know. But I bring this up because now we're going into some ideas of this new facility. I bring this up because it's reported that the facility, well, let me back up and say this. The counties in Texas, primarily tax funds come from property taxes. That's the primary source there's other sources, but that's the primary source. And unlike the two facilities, the one that's being built now and the one that is existing there, unlike what Bob has written about quite a bit in his, and the ones he talked about being sold at auction, the county, Karnes County or any arm of the county does not own the facilities. These facilities are owned by the GEO group. They're the ones that have built it, they bought it, and they're building it. I mention that to lead to this. The last year I was in office as county judge, our taxable valuation was a little over $500 million. When you, and I've got a lot to cover, when you take, and I'm not following my recipe, am I? Not sharpening. When you take a facility that is, I've been reported $32 million, when you add a $30 million facility to the county taxes valuation, that means close to 6% of your taxable valuation is being added by one facility. That means it could mean as much, at the tax rate that we have, it could mean as much as $150,000 a year in taxes. Now, the new facility, they're going to have, I first saw about 30 ICE employees, federal employees. I understand now they're talking about between 40 and 70 GO employees. Additionally, somewhere between 100 and 145. This includes a doctor that will be on staff, I'll be there 40 hours a week, x-ray technician, dentist, a dental technician, 4 registered nurses, 4 licensed practical nurses, a healthcare administrator, and a psychologist. Annual salaries with benefits over $7 million. Again, utilities be added, and I've gone over that. Indirect costs to the county, pay about $10,000 annually. And they will house 30 prisoners, county prisoners, for no cost to the county, not in the new civil detention, but in the other detention facilities they have. The new facility will have rooms for 8 individuals that open into a courtyard. Now, you know, no one likes to be restrained in their liberty or locked up, but these rooms will not be locked down. Each room is air conditioned. They will have restroom facilities with a shower, a microwave oven, and a flat screen TV with cable. This is in each one of the 8-man rooms. The courtyard will have a soccer field. There will be a gym with a basketball court, a library, a chapel, laundry facilities, and the uniforms that will not be the normal orange or black, orange or striped, whatever you may see. Uniforms will be khaki pants with a blue shirt. Another question that was asked, and I know I'm about out of time. Another question I was asked was that voters. In the year since this has been announced, almost a year, I've not run into one person in the county that has said this shouldn't be done. Not one voter. Asked about voters. Not one person said, no, you made a mistake by letting Jill build this. And obviously, the other question that was presented to me, what I think about subcontracting prison operations to private companies. Obviously, I'm opposed to it. Commissioner's Court voted for it. I signed the contract. I signed the contract that allows Jill to build this facility and operate it in our county. A couple of things that I do want to mention that Laura, you've said it's $122 a night. I signed the contract I think it's 2010. With the present facility that they have, they're getting less than $55 a day, not the $122. Yes, I was not a good negotiator, but we got it up from $45 to someplace between, and I don't have the exact figure, but less than 55, more than 50, but less than 55. And the initiative you talked about, where they're making the detainees, the illegal entrance criminal. I worked for a federal judge back in the 60s, Judge Conley, who had Laredo, and Houston. He was chief judge of the Southern District of Texas. We spent a lot of time in Laredo. And I will tell you from personal knowledge that in the 60s, anyone that was there at least 3 times, I think it was 2 times, became considered was handled as a criminal violator of federal law. I again am glad as a county judge of Karnes County that we were chosen to house this new facility, and in hopes that it will be the standard for new facilities in the future as it is purported to be. And hopefully there'll be a chance for answering any questions.
Thank you to our 3 presenters. I think we'll go straight to the questions from the audience, because I imagine there will be many, but we'll give you each a chance to respond to those and to each other.
I'm a private attorney. I do a lot of pro bono work with immigrants. And I'm from Alabama. And there's a concern that it has been difficult when I have clients who are, where the district attorney calls ICE on these clients. And it varies by attorney and it varies by judge as to what occurs. some for the smallest offense, ICE is there to pick them up, and at other times it's only for felony offenses. So I guess my first question is, do you have any suggestions, any of you, on how to engage the local county and city officials to come up with some standardized way that we can address which clients are going to be forwarded to ICE, so we can counsel our clients as to what they should do, particularly when I know there's a warrant for their arrest. And second, where you say that there are such different standards where sometimes I have no problem calling and I will be immediately put in contact with my client in ICE detention. Other times, I don't know if they're still in Mobile County. I found a few in Texas. There was no way to find them.
I'm going to answer first as the jailer. One of the first things I did when I came back to New York City as commissioner was to be respectful of the long-standing interagency agreements that there are in law enforcement between sheriff's departments, police departments, marshal service, and now, of course, ICE as well. But within my authority to level the playing field. And as we've heard already mentioned, that there is no right to publicly funded counsel, and there's no functional equivalent of a Miranda warning in civil matters. And whereas all law enforcement on the criminal side, when they come into our facilities, they're in an identifiable uniform, and they must identify themselves by organization. What we did was to say that we will produce individuals to be interviewed by ICE, but only with certain provisions having been put into effect, and they remain in effect today. And that is an identifiable uniform. It's a khaki polo shirt with the ICE emblem, the presentation of the ICE credentials, the identification of the ICE agent as an ICE agent. And before that happens, that the inmate, because they're still with me for criminal reasons, that they are advised that it is ICE that wants to see them, not an attorney or some other unidentified authority, which used to be the case. And that they have the opportunity to be interviewed, to refuse the interview, or to agree to an interview, but only with counsel present, counsel that they will have to fund themselves. And this has I think, empowered a population to make a good decision. There is recent case law. I talked before how little there is, and one of you will know the citation. I can't remember it off the top of my head, but we're now in minor matters. Counsel must notify and must advise their client that accepting even a plea bargain creates a criminal record, and that can have implications when it comes to removal decisions. I'm a little chagrined because I don't see a lot of aggressive movement on the part of defense counsel, particularly publicly funded defense counsel, to really proactively enact the holding of the court. I've reached out to the Legal Aid Society, for example, in New York City, and give me posters, give me brochures, I'll put them up, and that hasn't happened yet. But that's, again, for all of you, that's something that that can be done. But when it comes to secure communities, it's still a very fluid thing, and there appears to be a lot of inconsistency, and then you have 24 field offices around the country, and although there's direction that comes from DC, there's quite a bit of individual decision-making that still appears to be occurring.
If time permits to answer as a former prosecutor, in Texas, and I think it's been about the last 6 years, maybe as many as 8, one of the requirements in a plea bargain, not in a plea, when a judge takes a plea, has to inform that person, ask them if they're here legally, and inform them that well, they don't ask, they inform them that a plea could result in deportation. It's not, they're informed of that. And as far as how do you, I don't think there's going to be any way that you're going to get a consistent response to this situation, other than, like I say, when the judge has to takes a plea, has to inform them that this can happen. Because every prosecutor, speaking of the state of Texas, is elected, and he has the choice of proceeding how he wants to. One prosecutor that I recently worked with, anyone that was not here legally, ICE was notified. If they showed up and picked them up after the plea, that was ICE's decision, not ours, but they were notified. So you're not going to get anything consistent, in my opinion.
I see a couple more hands, so in the front, and then Sue. Okay.
Thanks, hi. I tend to try to find the bright side of certain situations, and even though it's getting harder these days to do it when it comes to immigration detention, but I have a question for Commissioner Sherrero and for Mr. Leibel, if you guys could take a crack at this. We've heard from Judge Kendall about the bright side of profit as a motive, in terms of there being all the benefits to the county, and as well as a new type of detention facility. Can profit as a motive ever be a good thing for reform of immigration enforcement or control measures, in your opinion?
I can always count on you for a good question. It's a huge motivator. I mean, it's fundamental to human nature. So the challenge is how do you make it so that ICE has contracts with vendors that in some instances provide on-site monitoring, and in other instances make these annual evaluations, that those findings need to be used for something. So to create contracts that incentivize exceeding minimum standards, and also build in liquidated damages or other kinds of penalties for not meeting minimum expectations, and that when there are repeated failures to meet minimum expectations, to impose the most stern of sanctions, which is cancellation of the contract.
Yeah, I mean, I agree certainly with that last point especially, right? I mean, I think that all of us have been very frustrated at ICE's, I don't know if it's inability or unwillingness to cancel contracts with facilities that have been notorious violators of standards and, basic human rights. I mentioned, I don't know if I really fully explained it, that the Tent City Detention Center, ICE did end its contract, but my understanding is that because of local economic pressure, before ending the contract, they negotiated with the Department of Justice to award the facility a $500 million contract to become a Bureau of Prisons criminal alien requirement facility. So basically a lot of folks who are now going through the criminal justice system and being prosecuted for re-entering the country are ending up there. So it's kind of the same population, just under a different framework. But, to the question, I think we have to, I think that in individual facility contracts, right, yes, like, if you're going to have them, then incentivizing, standards and having ways to kill contracts when the standards aren't met. But I also think that sort of more broadly, right, if the private prison industry, as I think Laura Sullivan pointed out, right, the incentive is to continually expand, right? The incentive is to continually find new markets of people to incarcerate. And I don't know how you disincentivize that, right? I mean, people are often asking, well, what can we make the private prison industry do to make it better? And there, certainly better contracts, I think, lead to better standards, but I also think that as an industry, right, its incentive is to continually find people to incarcerate. And once the immigration, once they've incarcerated as many immigrants as they can incarcerate, they're going to go after a new market. So.
If I could just add to that, there's benefit to the counties as well, because they, you know, as the judge had, you know, very candidly pointed out, they accrue benefit, financial benefit, direct and indirect. And so in a number of the places that I went around, the county would get X number of dollars off the top, and then the vendor would get the rest. I'm just to stir it up a little bit more. My own personal impression, with all due respect, when it comes to trying to fix something, like a place like Willacy, which was also an IGSA, an Intergovernmental Service Agreement, so technically it's government contracting with government, but at the end of the day, the sheriff is largely, you know, he's just not there. He doesn't maintain a presence in the facility, and he doesn't actively get engaged in the compliance with the IGSA. And so my own feeling is if you're, because ICE has the model where they contract with a lot of governments and then also with a lot of private prison providers directly, in some ways it's easier to deal directly with the person who's delivering it. It just takes so much longer. It may be great in your county, but in general, both on the correction side and on the immigration side, it's just easier to deal with one person in charge and get it done.
And my understanding is that one of the reasons that intergovernmental service agreements are utilized so much is because ICE can get around certain requirements in the contracting process, including competitive bidding processes that make them do, you know, like a sort of a series of hearings, right? And when you do an intergovernmental service agreement, you don't have to do that. And so, you know, again, it goes to the motivations and transparency and all of that.
You're okay. We still have 15 minutes, so.
I have a question.
Yeah.
Mr. Leifel, I am Hispanic, I am from Texas, and was raised in Laredo and born in Brownsville, so, you know, I could see Mexico from where I grew up. The history of Texas, as you know, has been a very violent and very heavy-handed and oppressive with Hispanics. So my question to you is, do you feel that because of that history and because of the cultural implications, not just profit, but because you're talking about people who look very Hispanic and because of the way they look, do you think it makes it easier, or in some way there are people who have the power to make those decisions to incarcerate Hispanics? Does it make it easier for those prisons to be built?
Well, I mean, I think that the history of the prison system in this country, right, is one that is very racialized, and that in different places it acts in different ways. But yes, I mean, I think that if these policies targeted white people in the same way that they targeted black and brown folks, no, I don't think we would have a prison system that's as large as we have. But yeah.
So, name and then in purple.
Hi, and this is for Commissioner Ferrero, and we've met before, but for identifying purposes, I'm with Detention Watch Network. And first of all, I want to say, yes, your report is known as the Ferrero report, and it is still, you know, very much looked to, and I actually sent it to a DC reporter last week so they could educate themselves about this and what's wrong. And I actually read it a few months ago again, and just really, it's been such a marker for the community of advocates really trying to work toward reform, to have something to point to and have someone with your experience and your perspective really come in and look and say, look, this is what's going on, and I've seen it from all these perspectives. So it's been incredibly valuable. And just to, I feel like it's something I want to say to you next time I saw you, so I'm going to say that publicly. But also, so it's also part of that profound disappointment, right? I mean, this really very strong, hard-hitting report, you all should read it, go online and get the Ferrero report. Really just lays it out and is a cookbook for things, for how things can be reformed. And so it's just, we are experiencing across the board, so many people in the room, incredible frustration and disappointment. And so I really hear you. I mean, I tend to be a kind of a builder, right, not a fighter. When you say, well, let's work to build, to work on a solution and not just it's really hard with the way that things are shaping up. And the fact that, I mean, I think you really hit it, nail on the head in terms of competency and commitment and also capacity. Thank you. 3 C's. I mean, do you have creative, things that you feel you can share, creative solutions about how we could really push the agency to do what's right and what they've said they're going to do? Because frankly, we're being told that basically the word civil doesn't have any meaning anymore. And really, that's an aspiration that's so far in the distant future that we're never going to see that. So how do we negotiate that and still, try to be at the table for many of those who are engaging in that?
This might sound like I'm setting the bar low, except for those of you who know directly or indirectly about the general level at which these facilities tend to operate. And I go back to case law. If as the most minimum expectation we were to say, you can promulgate whole sets of standards and regulations to enforce them, but if we had this one common assumption, one common agreement, and that would be that those individuals who are held by ICE or its agents for the sole purposes of immigration decisions, that those individuals, where they are held in a secure setting, no matter how soft or hard it is, that their conditions of detention should be at least the same and never less than, never worse than individuals who are being held on criminal charges or serving a sentence as a result of the plea or pleadings that would follow from being held on criminal charges. And for someone who's optimistic and always reaching here, I'm not suggesting that we settle there by any means, but to even establish in a conversation, and hopefully sometime soon in law, that the conditions of civil detention, I'll say it purposely, have to be no less than, would immediately raise the bar in so many different ways, in so many different locations. One particularly significant example, I've referred several times to healthcare. Healthcare, as I said very plainly in my report, is a fundamental right. And one of the things that is of great concern about the approach to delivery of healthcare as it's executed through DIHS, and now it's called something else. It's the agents that do off-site, special approved medical services, is that in the corrections arena, no matter how bad a system might be, when you need something, you get it. It's not conditioned on how close you are to parole or how close you even are to execution. If you need it, you get it. And that is not, I can't speak now with the same certainty that I did when I was there, but at the time of the writing, treatment, even assessments to determine the need for treatment, were routinely conditioned on anticipated time to removal. So I'm really not suggesting that you settle for less to suggest that if we just start there, you don't want to end there, but if you just start there, you will have made an appreciable improvement. And that's also back to the good question about, well, how do we take profit and use it, to the community's benefit? And so to create expectations that exceed minimum and to be prepared to compensate organizations for meeting those higher expectations. That little bit of extra money goes a very long way in terms of improving the quality of lives of individuals who are no longer there for criminal purposes. I don't know, how's that sound?
So I appreciate the answer.
I'm sorry, can I just speak, again, I know I'm the oddball here, but, what she was saying, I think you will see, or if you look at the staffing, or when you get the chance to see the staffing of the new facility that's being built by jail there in Karnes County. And like I said, it has a doctor, 4 nurses, registered nurses, 4 LVNs, I think they call them, psychologists. I mean, I do know during the negotiations for this facility, or how it's going to be constructed, and I forget what DIHS or whatever the organization. Well, at the time, anyway, they were very much a part of. This is what you have to have in this facility. You've got to have, they made them expand or they've had from the original proposal, they've expanded the medical facilities. They've expanded the number of medical staff that's going to be there. Again, I realize that you call it civil detention. No one likes to be detained. No one likes to have their movement restricted. And as a person that spent years aboard a ship, I know what restricted movement can be when you're out 6 weeks, 2 months at a time. So no one likes that. But I think what they are doing there at this facility sounds like a lot of the things, and I haven't read your report, and I apologize for that, but sounds like a lot of the things that you asked or put in there, they're trying to put into this new facility. Again, you need to look at the staff, because people need to look at the staffing at this facility building. They have actually someone for athletics. They're going to have a full-time person on staff to counsel athletics and other matters of that. And I know I'm running out of time, taking time, but
There was one more question I want to make sure if they're able to. There was another hand up there. Did you want to?
Yeah, that sounds great. I was wondering, given the widespread documentation of human rights abuses in these detention centers, why hasn't there been a class action suit filed?
Play my not an attorney card here. Anything else?
It seems pretty easy though. I mean, people are dying in these prisons.
But they have no stand there, right?
Exactly.
I mean, they're not,
Those stand.
they're not going to follow.
Did you want to ask a question?
Well, I have not so much a question as a comment, because I'm a chaplain in a detention center. And everything, I understand everything that both Mr. Kendall and Mr. Earl have said, but what I have seen is that we need to really monitor and back up the monitoring, because whether it's every year or every so often, I've seen what has happened, especially with the medical facility at one place where I was at. You know, the medical, they had a doctor, they had a psychologist and whatever, but they were not being really checked as to were they doing their job, you know, like they were supposed to. And the other place doesn't have any, so, you know, so I would say from the person working inside the facility is that we need to really monitor them correctly so that they, once they sign contracts to do what they're supposed to do, that they do it. That's where I'm at from my point of view.
This is a great way to maybe wrap up this conversation. When I talked before about the 3 C's, and I was referring to capacity in particular, and I mentioned before that ICE excels at enforcement, detention, not so much. And until there is expertise, until there is capacity within ICE to know what to do and to be able to ensure that it occurs, whether it's the design, the delivery, or the oversight, there is no way that looking to sheriff's departments and looking to private prisons directly and indirectly through sheriff's department is ever going to go away, because ICE lacks the capacity to operate its own facilities. And so it had good instincts when it entered into contracts, again, with vendors to provide oversight. But if you don't have the expertise, if you don't have the capacity, how do you know if you've written the RFP correctly? How do you know how adequate the response to the RFP is? when you get the report from the monitors, no matter how competent those reports may be, if you don't have the competency to evaluate those reports and to make your own independent judgment as to whether or not the recommendations are appropriate or adequate or anything else, we continue to be in this conversation where as long as there's detention, and there's always going to be some, hopefully smaller someday, bigger now, ICE has to, government has to know how to perform this core governmental function. And at the end of the day, back to your point again, whether it delivers it directly, which is clearly aspirational at this point in time, or through others, whether it's good counties and the private sector, that it never can delegate the fundamental responsibility for the results. And so that's maybe where we continue the next conversation after the break.
You all have very carefully and wisely anticipated other parts of this program. The question about race and color is something we'll be taking up in the next panel this afternoon. The question about litigation, class actions, we have a panel on advocacy tomorrow morning. Right now, we have a coffee break. Let me explain. Because it's a class day, there's not any space in the building for so many of us. Our coffee break is across the street in Dunbar's, but you don't have to pay for the coffee. And there are also some vending machines there if you want other things. The elevators, again, there are only 2 elevators here, so you may also want to use the staircase here down to the ground floor and then across the street. The law students can help you find Dunbar's. But there's also an area outside Dunbar's to the left that'll lead into the interior patio of the new clinic building there, which is a nice place to stand around and visit. We'll be back here right at 4 o'clock for an interview with a former detainee.
There are also copies of an article that